Good. Okay, so we've had four excellent presentations, kind of covering the legal background, geopolitical background, and also some of the approaches to key issues around privacy and security by the Chinese platforms and government. And now we would like to turn to our discussant, who is Roger Creemers, a assistant professor in modern Chinese studies at Leiden University with a background in sinology and relations and law. And his research focuses on Chinese digital technology policy, excuse me. He is the director of the Leiden Asia Center, which is a project on China and global cybersecurity. Welcome, Roger.
Thank you very much, Brendan. And let me say what a pleasure it is to see many of my old friends also from China in the session. Obviously, we cannot travel there right now, so 见到你们我非常高兴，希望尽快能够回到中国去，彼此互相见面。Good morning from Europe, where the sun is slowly starting to climb over the horizon. And I'm saying this to a certain degree because I literally sit in the middle between China and the United States. What I would like to do from that sitting in the middle is offer a little bit of a sort of abstracting what I think are some of the key questions that we're trying to get at in what we're trying to do, and see how we as academics, researchers, can develop a research agenda around some of these central themes that allows us to overcome what I think has been one of the key inhibiting factors in our work, and that is the fact that both in more popular and policy discourse and in the academy, when we talk about these issues of platform governance and everything that is sort of connected with that, we very often essentially start from the basis that regime type is the key variable. You know, liberal democracies do certain things one way, and non-democracies do things a completely different way. And so every outcome that we see in the end can be brought back to regime type. And obviously regime type has some influence, but I think focusing only on regime type obscures sometimes more than it illuminates. Sometimes states do things not because they are any particular kind of state, but because they are a state. I'm very much channeling James Scott here. Seeing like a state. There are some things that any state just needs to do in order to function. The second thing that I'd like to bring in here is that what we're seeing is that many of the topics that we're discussing, including things like privacy, targeted advertising, but also the national security and strategic concerns that Chuan Ying brings in, are worldwide trends. And these worldwide trends manifest themselves in specific ways, conditioned by the environment in which they manifest themselves. But that doesn't mean that they aren't part of the same overall trends. And I think in general, when we talk about the platform economy, I think we can safely say that worldwide, we were a lot more optimistic about the influence, the impact of what digital platforms could and would do, say, 6-7 years ago, than we are today, right? I think we can safely say that worldwide, we are dealing with, I'm not necessarily going to call it a dissolution with platforms, but certainly a more nuanced and realistic sense of the potential risks, harms, and costs that they bring to political, economic, and social interests. And that, therefore, where, you know, until fairly recently, we sort of, and I still haven't completely figured this out, but I think it's a combination of everything, that you can't regulate these platforms, you shouldn't regulate these platforms. So it's both, right, that was both a normative and a factual assertion. It's neither possible nor desirable. And we seem to have been moving back. We seem to have moved away from that quite rapidly, certainly in China, as we've seen in the most recent round of regulation, amongst others in anti-monopoly and financial services, as well as data coming in over the last half year or so. Certainly in Europe, where the digital markets and digital services package, it's working its way through the Brussels sausage-making factory. And even in the United States, where I think the US was very much an outlier on this. When I look at the head of steam that is building most recently with the appointment of Lina Khan to the antitrust, the FEC. Sorry, woke up at 3:30. I think, this is someone who made her bones in thinking through antitrust as it applies to Amazon. So I think we can really clearly say that there is an overall trend that platform governance is an issue, which is also evidenced by the fact that we are having this conference, and I'm very happy to join it. And if I may share a personal anecdote, but Chuan Ying and I, a couple of months ago, held a small workshop with European and Chinese academics and researchers on the very same topic. At that point very much focusing on the anti-monopoly and financial services regulations that were coming in China, as well as digital services and markets package coming in Europe. As we were working through planning the topic, we were sort of going how this was a very new thing and no one had really worked on it before. And suddenly, as we see in this conference, it's mushrooming again. It's mushrooming very much as a point of interest also in the sort of China, America, Europe sort of framework. So indeed, a very important topic. Then let me go to the individual presentations, and I'm just going to briefly identify a few points which I hope can serve as a starting point for a discussion now in a couple of minutes, but certainly also in the further research collaborations that I am sure will spring from these from this conference, which I would be very happy to participate in if useful. So I'd like to start with Hunter, and I think what Hunter does is something very, very important. Hunter points us back to a warning which, at least in the field of Chinese law, was given by Donald Clark already in the late 90s. And that is that one must be extremely careful, even with using basic words and basic terms that we think are neutral, but work completely differently in different environments. And what I'd like to pick out from his presentation is this notion of the split between privacy and personal information protection. Now, as you know, I work as part of DigiChina, and we've been doing a lot of work on the personal information protection law recently. And one of the things that I keep saying time and time again, but we haven't sort of come around to making an editorial decision on that, is that keep on saying that we shouldn't call the personal information protection law a data privacy law. Because, on the one hand, from a US perspective, data privacy is the term that is generally used for what the PIPL is trying to do. But in China, privacy is a term of art, and it denotes a distinct field of law, which is about information that you would like to keep confidential. It has its own couple of articles in, amongst others, the Civil Code, and we will come back to that in my comments on Li Sherman's presentation. But so privacy and personal information protection are two different things in the Chinese legal system, even though they are not in the American legal system or indeed in the European legal system. So if we fail to understand that even the words we use have consequence for our analysis, we can never hope to get the analysis right. And I very much commend Hunter for bringing that to our attention. The second thing that I wanted to pick out from Hunter's presentation is indeed, the importance of institutional and systemic differences, and in this particular case, the importance of courts. Now, I've been doing Chinese legal research professionally for about 13 years or so. And one of the things that has always struck me is the fact that, the field is largely populated by American scholars, but they seem to have to overcome a few more intellectual barriers to get how the Chinese judiciary fits within the broader system than my continental European colleagues. And the reason for that is that, China's judicial system is built on, civil law jurisdiction examples, obviously also a little bit of Soviet influence there. But in general, one thing that is completely different is the role of courts. And what I find is that American scholars, very often having been steeped and marinated in the American common law tradition, not just not even the British common law tradition, but the American one, where, courts obviously play an extremely important role and we have Marbury and Madison and all of that, find it very difficult. It almost seems like there's a lot of projection going on. And what some American scholars consciously or unconsciously seem to be doing is sort of going, this is what we have in the United States, therefore this is what I'm going to look for in China. And that's simply not how that works. Courts play a completely different role in the Chinese system. They do not make law in the way that the Supreme Court does or the Ninth Circuit Court does. They are administrative actors that indeed, and I also commend Hunter for having gone into some of the case research, and I would love to connect separately and talk some of these things through, because you had a couple of very interesting points there that I hadn't come across yet. So feel free to hit me up on email. But in some of the cases that you see is indeed courts are very good at bread and butter issues once there is a law that they can rely upon or a piece of regulation that they can rely upon. But what courts in China really aren't set up to do is the big landmark case that not just sort of results in a couple of billion in damages or fines or whatever, but also the landmark case that creates an entirely new field of law. This is something that we shouldn't be looking for in China, simply because the system isn't set up to exist or to function in that particular way. So in other words, we need a far more solid grounding in terms of mutual understanding in how the particularities of each system influence the outcomes that we're going to get as we move through our effort to understand these local manifestations of global trends. Then coming to Chuanying's presentation, one thing that I was thinking about as you were presenting, Chuanying, is call it the Dutch East Indies Company, but also the British East India Company, because perhaps that was the last time in global history that private companies had as much power as some of the platform companies seem to be doing today. Not to say that Facebook is going to, conquer China with a private militia or India or, colonize in the way that the old East Indies Company did. But to say that what we are presented with from a strategic and national security perspective is a new kind of powerful actor that I don't think we yet have a sort of an adequate conception for, or one that introduces an unstable situation that cannot exist in the long run. What do I mean by that? Well, if we look at the modern state, the way that we created the modern state, certainly in Europe or more broadly in the West, is by identifying sources of private power and gradually bringing them in the remit of the state. So we took power away from kings and aristocracies and guilds and individual companies and the church, and we put it into this new thing which we called the state, the public sphere, which then we gradually made more and more democratically accountable. And that's, I know it's a bit Whiggish, but that's a capsule history of Western state formation in the last couple of centuries. China obviously did it in the current form. The People's Republic of China did it through the establishment of a communist regime along Leninist lines, where again, this is characterized by the monopolization of power within, in China, the party state. So, there are some clear similarities there. However, what we're seeing now is you have these companies that are incredibly powerful, do have an important public role to play. Just refer to the January 6 kerfuffle in and around the Capitol in Washington, and the role that Twitter played in that, but more broadly, the role that Twitter plays in American but also European political discourse, right? It's almost become a utility in that respect. But obviously also the fact that, for a Chinese citizen today, certainly one living in the bigger cities, Alibaba, Tencent, these have become things that you cannot live without or only with great difficulty. In China, furthermore, we see, that these digital platforms occupy a very interesting position in the Chinese economic structure. where in the early 1990s, as Deng Xiaoping created this called for the socialist market economy, we ended up with a sort of dual economic split, where on the one hand you had the strategic commanding heights, things like energy, media, banking, the automobile construction, which were strategic commanding heights and which therefore were and are dominated by state-controlled or state-owned enterprises. And then the rest of the economy where, the private sector plays the dominant role. And the interesting thing is that the internet sector developed as part of that private sector, but obviously has gained strategic importance. And so it's a little bit of a strange bird in the aviary of the Chinese economy. And again, it's a variation on that theme. But what we're seeing equally with platform governance in China is an attempt to square that circle of how do we actually deal with this enormous emergence of private power. And in my assessment, I'm not sure it's something that can exist for a long time. I think, it creates instability in an existing system, and the system will reimpose stability somehow. Again, very much in line with its local circumstances. And this is where Chuan Ying's point about, what role do local rules here play? And what does that then mean in geopolitical competition or geopolitical tensions, as we're seeing have developed between China and the United States in recent times? We may see certainly a more a closer alignment between platform companies and the state, not necessarily because the companies want to or the state want to, but because the situation as it exists is unresolved and will find some sort of resolution, because I think we can safely say that no one is really happy with the way that things are going right now. Then Li Shimeng, I always love a really detailed presentation that goes into the nitty gritty. It's all fine to be a sort of big blue skies thinker, but it's also good to go into the detail. And one thing that I wanted to pull out from that is that, surveillance capitalism seems to be as alive in China as in the United States. And it really sort of points me to, I think, one element that we all have to contend with, and that is advertising, and more broadly, what advertising represents in the digital platform ecosystem. Now, personally, I really, really, really dislike advertising. It's and the reason for that, it's very simple. Advertising, targeted content is a tool to make people unhappy, because what advertising is trying to do is it's trying to tell you that your life isn't good enough, that you need a new holiday or a new house or a new car or newer clothes or newer whatever, because whatever you have today is not good enough. So spend. And I think a lot of people dislike advertising. This is particularly going to create a problem in the West, because when you look at the incomes of companies like Twitter, but also Google and Facebook, advertising is north of 90% of their takings, because there we end up with the second problem, which is that the promise of these companies is that they are more effective than traditional advertising venues in connecting potential sellers to potential purchasers. Now, there is a really good book, it's called If Then by Jill Lepore, that talks about sort of the invention of targeted advertising and data-enabled profiling in the United States in the 1960s. And it's a real eye-opener. But the point is, a lot of that stuff didn't work then and doesn't work now. So a lot of what these companies are trying to do is essentially smoke and mirrors. They're trying to present something as working, which, in very many ways doesn't really. And I'm not just talking about, the basic thing that, let's just say, my daughter is having her birthday in 2 weeks' time. She's turning 6. And so I bought her a birthday present. And the interesting thing is that I just bought this birthday present, which is a particular toy. And now I'm getting all kinds of advertising for that toy, which I just bought. And I'm probably very unlikely to buy a second one off. So anecdotally, you have a problem there. But more broadly, we have an advertising model here that is vulnerable. It's vulnerable, one, because the value proposition is flawed. It's vulnerable, two, because it makes people unhappy. And therefore, it's vulnerable. 3, because at some point regulation may well move in, as Shimon is suggesting in her presentation, is already happening in China, and I'm sure that is going to, and it's also part of, the digital market, digital services package here. I'm sure it'll come in the United States. So this creates a tremendous sense of vulnerability for these platform companies. The interesting comparison in China is that a lot less of the revenue of Alibaba, Tencent, and other companies is advertising based. Because very often they're in the business of making money through other services that people actually do want to pay for. So a really interesting comparative question would be, what does that mean for these approaches to surveillance capitalism as we see them in Chinese and Western tech platforms?
Roger, we're at about 5 minutes to midnight here.
Okay, I've got one more thing, and then I'll be done. Okay. And then to come to Wang Xixin, and the last thing I wanted to say about Shimon, apart from that potential comparative angle, is that it also creates a really new link, an interesting link between personal information and privacy protection in China. Because in essence, what are we talking about here? Is it personal information protection because it uses personal information? Is it privacy protection because it seems to be, dealing with the right to a quiet life, which is one of the personality rights in the civil code? So a very interesting overlap that I think Chinese lawyers will have to look at a little bit. Johan Hua has already sort of said a couple of things to that effect. And then about Professor Wang's presentation, again, the real big problem here to any real name registration is anonymity. And why is anonymity a problem? Why do we want to solve anonymity? And as I already identified, no pun intended, in my comments or in my question yesterday, I think the key here is accountability and responsibility. And how can you be accountable and responsible for the consequences of your actions if you're anonymous, right? And the thing is, we've got all kinds of real name registration system in our daily lives. The license plates on the back of our cars are real name registration systems, so that if we burn a red traffic light or we run through speed limit, someone with access to the decoding algorithm, i.e. the DMV database, can decode our identity. And for that reason alone, I presume that we are going to see more and more real name registration systems happening. However, I think Professor Wang is also right in identifying some of the chilling effects, particularly in regards to online speech, that are important here. And this is again where I think we're in an unstable situation that needs to be resolved. And the way that it can be resolved is by maybe reference to traditional media approaches where you could have source anonymity because you had editorial responsibility. And obviously in the United States, this ties into the Section 230 debate. I'm not necessarily saying platform companies should be responsible, but perhaps there can be new forms of media association where at least some editorial responsibility can be taken for online anonymous utterings. At the same time, I don't think in the realm of online speech, we should be over-optimistic in terms of what it might do to trolling. Obviously, it might do something to things like Russian disinformation campaign and sort of online bots, which I really think are a problem to be solved. But at the same time, if we're talking about toxic content, Tucker Carlson is very much not anonymous and very much out there and upfront, and that hasn't stopped him from being an absolute twerp. And with that, I'd like to conclude my comments and hand it back to Brendan. Thank you very much. I hope you find
Roger, thank you so much to get up at the time you did and give us the tour de force of feedback that you just did is quite impressive. So thanks again.